all of that is where does the protection of the public interest comes in? I mean, we can't be having people sitting on boards
Proceedings have resumed.
The Design Rights Bill 2019.
The Honourable Minister, Financial Services and Home Affairs.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled the Design Rights Bill 2019.
The bill has been duly moved. Is the Minister ready?
Yes, Mr. Speaker. Mr. Speaker, I rise to present the bill on behalf of the government. It is a bill that makes new provision for the protection of design rights in the Cayman Islands. The bill seeks to provide the mechanism for the registration of design rights in the islands without the need for the applicant to register or for registration of the design right in the United Kingdom. As a consequence of this, the bill seeks to repeal the Design Rights Registration Law 2016, which provided for the protection of design rights held in the United Kingdom and the extension of those rights to the Cayman Islands. Mr. Speaker, on August 1st, 2017, the Cayman Islands commenced the registration of design rights by way of extension from the United Kingdom through the Design Rights Registration Law 2016. You see, Mr. Speaker, at that time, design rights were the only one of four major types of intellectual property that was not protected in some way under Cayman Islands law, and the introduction of an extension system was the most expedient way to address this deficiency. Mr. Speaker, at that time, there were indications that the interest in design rights registration was, in fact, increasing. However, Mr. Speaker, since 2017, there have only been a total of 9 design rights registered. It is suspected, Mr. Speaker, that several factors have impacted the overall level of registration. First, the Design Rights Registration Law 2016 provides that design rights can only be registered in the Cayman Islands if the applicant already has a valid UK or community design right registration. Mr. Speaker, this means that major brand owners do not need to take steps to register their design rights in the Cayman Islands if they have already obtained a registration in the UK. This is because brand owners are aware that a third party or competitors cannot register their design in the Cayman Islands, as they would first need a UK registration, which they cannot obtain as an application would be blocked by the pre-existing UK registration. Second, Mr. Speaker, the present system requires a business or person wishing to protect their designs in the Cayman Islands to incur the additional expense of first applying for and obtaining a UK or community design. This is a practical problem, Mr. Speaker, given the costs associated with such registration. And Mr. Speaker, it should be noted that by moving to a system to allow for direct local registration, which this bill will enable, is and will be of particular benefit to local artists. Thirdly, Mr. Speaker, offering direct registration will bring the Cayman Islands in line with other jurisdictions in the region, such as Jamaica, Belize, and Bermuda, for example. For the above outlined reasons, Mr. Speaker, the Design Rights Bill 2019 has been drafted to provide a one-step process of moving to only permitting local registration of designs and the conversion of all existing UK and community registered designs, provided that they do not offend any requirements of the new legislation. Mr. Speaker, I will now speak to the details of the bill in brief. The bill is comprised of 67 clauses in 6 parts, as well as a schedule of fees. Part 1 deals with the duties of the registrar, the requirement for the use of a registered agent, the application for the registration of a design right, and the annual fee. This part also deals with the publication of registrations, searches of the register, certificates of good standing, and the renewal or abandonment of a design right. Part 2 provides details on a design right as a property right and for its ownership, duration, and qualifications for design right protection. This part also deals with the assignment and licensing of rights. Part 3, Mr. Speaker, deals with the rights of design rights owners and the remedies in cases of infringement. It outlines the various types of infringement, the meaning of an infringing article, and the various remedies available through the Grand Court. It also speaks to the rights and remedies available for exclusive licensees. Part 4 deals with the exceptions to rights of design right owners. It speaks to the infringement of copyright in a design and the right to a licensee or to a license within the last 5 years of a design right term. It also addresses Crown use of designs, settlements in Crown use, and Crown use compensation for loss of profit. Part 4 also deals with the Crown use in cases of emergency and exceptions for private acts, experiments, or teaching. Part 5, Mr. Speaker, establishes a design rights tribunal and its jurisdiction to decide on matters relating to design rights, as well as referral of matters to the Grand Court. This includes settlement of terms where the design right owner is unknown and references of disputes relating to Crown use. Part 6, Mr. Speaker, deals with offenses under the law, reciprocal protection of design rights with other countries, the ability of the Cabinet to make regulations, the repeal of the Design Rights Registration Law 2016, and savings and the transitional provisions. Mr. Speaker, under Part 6, existing design rights will be transferred to the new register and considered as registered until the renewal date. So, Mr. Speaker, this is the overview of the intent, purpose, and the effect of the bill before this House today. And in coming here, I'd like to thank the staff of the Ministry and General Registry, and also the input of the private practitioners that work in the intellectual property space in helping to design this bill, and certainly the work of the legislative drafting team for actually helping to prepare the draft in front of us. And so this concludes my presentation of the proposed bill, and I commend it to this Honourable House for passage.
Does any other member wish to speak? The member for Bordentown West.
Thank you, Mr. Speaker. Just want to firstly, on behalf of most of my colleagues, rise to say that we support this bill. We think it's something that is timely. We think it's something that's actually needed, and I think it shows that the Cayman Islands is ready to expand our role in the international arena. While the minister did explain during our debate as to some of the benefits of bringing it there, I'd just be curious as she closes up, just to kind of explain why we, I guess, came up with the idea of moving it completely out of the UK. But outside of that, we welcome it, and I would say that it has the support of most members on this side. Thanks.
The member for Georgetown Central.
Thank you, Mr. Speaker. I rise only to share the sentiments of my colleague, simply due to the fact he said most members, so I've made to clarify that I do support it myself, and I wish the government and this administration, particularly that of the minister, continued success with the development of this bill.
Does any other member wish to speak? If no other member wishes to speak, we'll call on the mover for her right of reply.
Thank you, Mr. Speaker, and thank you to the member from Bordentown West and Georgetown Central for their vocal support on behalf of the members on that side, and certainly for the tacit support by the members of the government on this side of the House. for the passage of this bill. To kind of reiterate and answer the question posed by the member from Boddentown about Boddentown West about why we move from a system where the registration must take place in the UK first and then by extension to Cayman. The obvious benefits were accessibility, and as I said, for local artists in particular, it creates or it lessens the barrier for registration. They don't have to go outside the jurisdiction in order to be registered in the jurisdiction. So accessibility for local as well as international artists in that regard. Lowers the cost as well, the cost of registration. You don't have the duplication of having to register and pay the costs associated with registration in the UK. And then, of course, whatever costs and fees would be levied here in Cayman. So it becomes more cost competitive. And as a result of those two characteristics, the expectation is there's certainly interest in this area and that we may actually see more registrations taking place and therefore more revenue in the government coffers, but also more opportunities that would flow as a result of that. So I hope that answers the question as to why. And again, I want to thank this Honourable House for agreeing to move this to the next reading. Thank you.
Question is that a bill entitled the Design Rights Bill 2019 be given a second reading. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The Design Rights Bill 2019 has been given a second reading.
The Trust Amendment Bill 2019.
The Honourable Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill shortly entitled the Trust Amendment Bill 2019.
The bill has been duly moved. Is the member speaking there too?
Yes, Mr. Speaker. I rise to present this bill on behalf of the government. It is a bill that seeks to amend the trust law in order to enhance and modernize the legislation to ensure the continued viability of trusts as a financial services product in the Cayman Islands. Mr. Speaker, the trust legislative framework of the Cayman Islands constitutes an important sector of the jurisdiction's financial services industry. Legal arrangements such as trusts are utilized globally for estate planning purposes. In this regard, the Cayman Islands has over the years developed the expertise, experience, and regulatory infrastructure to adequately provide trust products and services to the international community. However, Mr. Speaker, the Cayman Islands is not the only jurisdiction which offers these products and services. And as such, the Law Reform Commission, Mr. Speaker, conducted a review of the trust law between 2017 and 2018 and set out in its findings in the Trust Law Report, which I'll refer to as the report going forward. The Law Reform Commission's review and the subsequent recommendations set out in the report were to ensure that the Cayman Islands remain competitive with other offshore jurisdictions operating in this sector. Mr. Speaker, the amendments contained in the bill are eagerly anticipated by local practitioners, as it will improve the operations of the law and possibly the usage of Cayman Islands trusts. It should be noted that in addition to the consultation with the Cayman Islands Society of Trust and Estate Practitioners, the Law Reform Commission also sought the insight of the Cayman Bar Association, the former Cayman Bar Association, the former Cayman Islands Law Society, and the Honourable Chief Justice in developing the report and the proposals therein. Mr. Speaker, the Ministry of Financial Services in turn also conducted further consultation with the Society of Trusts and Estate Practitioners in developing the amendments to the bill that we see here today as well. So, Mr. Speaker, importantly, the bill provides the Grand Court of the Cayman Islands with certain powers to give clarity and certainty to clients as it relates to trusts constituted under Cayman Islands law. These provisions include allowing the Grand Court to set aside mistaken exercise of fiduciary power, to make rules as it relates to provisions of the trust law, and powers to approve a compromise of trust litigation. Mr. Speaker, the bill is arranged into 8 clauses. Clause 1 of the bill makes provision for the short title of the legislation and commencement. Clause 2 of the bill amends the definition for trust corporation and inserts a new definition for the term trust litigation. Clause 3 of the bill inserts a new provision which allows the court to set aside mistaken exercise of fiduciary power and to approve compromises in trust litigation. Clause 4 of the bill provides the court with powers to vary trusts where there would not or be no detriment to that person. Clause 5 adds a provision that beneficiaries of Cayman trusts are excluded from being deprived of rights under the Cayman Trust by virtue of a foreign law. Clause 6 is a consequential amendment which deletes a definition which is now captured in Clause 2. And Clause 7 of the bill inserts a new provision to allow the Grand Court to make rules to give effect to provisions within the law. And finally, Mr. Speaker, Clause 8 is a consequential amendment due to the deletion implemented by Clause 6. So, Mr. Speaker, this in essence concludes the presentation of the proposed amendment bill, and I certainly would like to thank the work of the Law Reform Commission in taking this project forward, the work of STEP, Cayman Islands, the Society of Trust and Estate Practitioners, the former Cayman Bar Association, the former Cayman Islands Law Society, the Honorable Chief Justice, the staff of the Ministry of Financial Services, and the Legislative Drafting Department for their efforts with respect to the design and the preparation of this bill before us today, Mr. Speaker. I therefore commend the Trust Amendment Bill 2019 to this Honourable House for passage.
Does any other member wish to speak? The member from Bordentown West.
Thank you, Mr. Speaker. First, I want to thank the Honourable Minister for the presentation and also to thank the government for bringing this bill. We think it is most of us on this side think this is actually something that's quite needed. As I had mentioned previously before, Mr. Speaker, when we look at the number of registration, both in the banks and trusts and even in the nominees trust section, there have been a steady decline over the last 17 years. Just again, looking at stats provided from the Cayman Islands Monetary Authority, just to put things in context to this Honourable House. Back in 2002, Mr. Speaker, we had 22 entities that was registered as bank and trust. That has now decreased to 8. And if we look at the nominee trust companies, Mr. Speaker, back in 2002 we had 89. Today we have 21, which is a decrease of 76%. So we believe that anything that will enhance the competition, the competitive value of the Cayman Islands financial services, and also anything that will continue to attract business to our financial services industry is something that we welcome. It is still foremost the pillars in which our economy is built on, and is not something that we can take very lightly. So we're very pleased to see the government doing something to kind of slow down the decline in this business, because at the end of the day, just to kind of give people a little bit of backdrop, the trust is very important to the banking business, because normally we get more assets on the trust. Those are deposits that the banks will have on hand. And again, if you look at our the same stats from SEMA, many of those deposits are what it is that fuel the local economy in terms of loans, mortgages, and everything else. So it is a very important business within our financial services industry, and we welcome the changes that the government is doing to enhance our financial services industry. Thank you.
Does any other member wish to speak? If not, I'll call on the Minister for her right of reply.
Thank you, Mr. Speaker, and again want to thank the member from Bordentown West in your contribution in supporting this bill on behalf of the opposition. And of course, thank my colleagues for their tacit support as well and for bringing this bill forward. And in particular, I want to thank the member for Bordentown West in helping to elucidate, of course, the importance of financial services to our economy, but also to show the interconnectedness between the different aspects and different subsectors within financial services and how one can impact the other. So I thank you for that elucidation for the benefit of the listening public as well. So again, want to say thank you to all members for your support, and I do commend this to this Honourable House for third reading after this.
Question is that a bill shortly entitled the Trust Amendment Bill 2019 be given a second reading and pass. All those in favor?
Aye.
Those against? The ayes have it. The Trust Amendment Bill 2019 has been given a second reading.
The Healthcare Decision Bill 2019.
The Honorable the Minister of Health. You want a podium?
Thank you, Mr. Speaker. Mr. Speaker, I would like to move that a bill entitled the Healthcare Decisions Bill 2019 be given a second reading.
The bill has been duly moved. Honorable Minister.
Mr. Speaker, I rise to seek support of the members of this Honourable House for the Healthcare Decisions Bill 2019. Mr. Speaker, for several years, concerns have been raised in the medical and legal fraternities and in the community regarding the absence of legislation that addresses advanced directives. Mr. Speaker, as you know, as an advanced healthcare directive, also called the living will, spells out a person's preference for life-sustaining medical treatment. Some of those preferred medical treatments and/or procedures are ventilators and feeding tubes that do not resuscitate, can also form part of an advanced healthcare directive. In 2015, at the annual Cayman Islands Healthcare Conference, the topics of end-of-life decisions and palliative care were discussed as part of the overall theme, embracing emerging trends. Out of these presentations and discussions, the stakeholders expressed the need for the Cayman Islands to start the conversation with families, patients, and caregivers, and to take the necessary steps to develop appropriate legislation and guidelines that will allow for a patient's preference about their treatment and end-of-life decisions to be upheld and honored. Mr. Speaker, in absence of the legislation, the Health Services Authority face many difficulties with families and caregivers of patients who are so unwell that they are unable to make decisions for themselves or express their wishes, or patients whose wishes and/or preference for treatment cannot be honored. Mr. Speaker, with this background, the ministry convened a committee in March 2017 to discuss and propose drafting instructions that would assist with the development of legislation to allow for the recognition of advanced directives. The committee included the following persons: the Chief Officer of the Ministry, the Acting Chief Medical Officer, the Medical Director of Health Services Authority, the Medical Director of Cayman Hospice Care, the Director and Nurse Manager of Cayman Hospice Care, a representative from the HSA's Hospital Ethics Committee, Chair of the Cayman Islands Medical and Dental Society, Chief Nursing Officer, Peen Specialist from the Health Services Authority, and the Senior Policy Advisor for Health. Mr. Speaker, the legislation that is presented here today is a culmination of over 2 years of dedicated work, including the feedback that was received from the public during our 60-day public consultation period. Mr. Speaker, before I get into the details of the provision of the bill, I would like to speak a little about the consultation period, which occurred during the period of the 1st of August until the 30th of September 2018. During this period, a number of media appearances were made by representatives from the Ministry of Health on Radio Cayman's Talk Today for the Record, Star 92.7, and Hurley's Media Rooster 101 and Cayman Now shows. In addition, a press release, frequently asked questions, and the draft bill were uploaded to the ministry's website. Comments were received through email submissions, and all the feedbacks were received was in support of the draft bill. Most of the comments received have been incorporated in the bill presented here today. Mr. Speaker, I would now like to speak to the provisions of the Healthcare Decisions Bill 2019, which is divided into 7 parts, 53 clauses, and a schedule. Clause 1 provides for the short title of the bill. Clause 2 provides for the interpretation section and outlines the definition of the terms, expressions used throughout the bill. Mr. Speaker, some of the proposed definitions include the following. Advanced Healthcare Directive means a document made by a person expressing that person's health care wishes in the event that the person becomes mentally incompetent, including, for example, that the person wishes to be denied life-sustaining measures if that person becomes terminally ill or does not wish to undergo another stated type of health care. Best interest of a directive maker means the directive maker's proper health care and the protection of the directive maker's health interests. This must be done with regards to guidelines of the General Medical Council and the Code of Ethics and Standards of Practice of the relevant local council. Brainstem death means an irreversible loss of the capacity of consciousness combined with the irreversible loss of all brainstem functions, including the capacity to breathe. Civilly liable includes liability for professional conduct and susceptibility to sanction or other adverse action for contravening a code of professional ethics or a departure from an accepted form of professional conduct. Directive means an advanced healthcare directive generally, and for a provision of this law about a particular proxy, the directive under which the proxy was appointed. Directive maker means a person who makes a directive pursuant to this law, and for a provision of this law about a particular proxy, the directive maker who appointed the proxy. An ethics committee means that hospital's ethics committee, and an interested person means a directive maker, a proxy of the directive maker, a registered practitioner providing health care to the directive maker, the directive maker's nearest relative, and any person who satisfies the ethics committee that that person has a proper interest in the issue. Life-sustaining measures means healthcare intended to sustain or prolong life and that supplants or maintains the operation of vital bodily functions that are temporarily or permanently incapable of independent operation, including, for example, cardiopulmonary, resuscitation, assisted ventilation, or artificial nutrition and hydration, but does not include a blood transfusion. Medical treatment means the provision by a doctor or a surgical or psychological therapy, including, for example, a doctor providing therapy to prevent disease, restore or replace bodily function in the face of disease or injury, or to improve comfort and quality of life, and B, prescribing or supplying medication. Mentally competent means that a person is conscious and during the course of making that person's decision has the faculties to be able to understand and retain and use relevant information to make the decision and to understand its consequences, except for technical or trivial information, has the faculties to be able to understand the nature and effect of the decision and be able to communicate the decisions in some way. Mentally incompetent means that person is unable to make a decision, as that person does not possess the faculties to be able to. Nearest relative of a directive maker includes spouse, children, parents, siblings, grandparents, grandchildren, uncle or aunt, niece, nephew or niece, cousin, close friend, mental health professional treating the directive maker, social worker or probation officer employed in government or statutory body, attorney, in that order of relationship with the directive maker, and in terms of age, the most senior. A proxy means a person appointed by a directive maker to make decisions about the directive maker's health care. Revocation wish means a wish expressed by the directive maker to revoke the directive at any time while the directive maker was or is mentally competent. Terminally ill means having an incurable condition caused by injury or disease from which there is no reasonable prospect of a permanent recovery, and for which condition death would, within reasonable medical judgment, be imminent regardless of life-sustaining measures, and these measures would only serve to postpone death. Wishes includes directions and instructions and wishes implied expressly, but does not include a wish that is a barred provision of a directive, or would be a barred provision had the wish been included in a directive. Witnessing doctor means a doctor chosen by a directive maker to witness the execution of that directive maker's directive. Clause 3 provides that giving or receiving of palliative care shall not be affected. Clause 4 provides that euthanasia and assisted suicide are not authorized. It further states that it does not affect the operation of the penal code except as provided in clause 37 and 41 of the bill. These four clauses complete part 1 of the bill. Mr. Speaker, part 2 of the bill, consisting of clauses 5 through 8, outlines the principles that are to be applied in relation to making of decisions and orders in respect of health care directives. The provisions in the part set out of the principles for the application of the law in relation to making decisions and orders in respect of the health care directives. Registered practitioners will act in the best interests of the directive maker to provide the appropriate health care, except where the denial of health care is explicit and an operative directive or the proxy has made a decision to deny health care. With regards to the principles of advanced health care directives under the law, a mentally competent adult may make a directive for that adult's own health care, thereby deciding what quality of life that adult wishes should they become mentally incompetent, and may delegate the decision to another person. If the directive maker later becomes mentally incompetent, the directive has the same authority as if the directive maker were mentally competent. Mr. Speaker, the bill also makes provisions to create the opportunity for the directive maker to appoint a proxy. This proxy has the same authority as the directive maker, as if the directive maker were mentally competent, and the proxy's decisions must reflect the decision of the directive maker and must be consistent with what the proxy believes the directive maker would have decided. Mr. Speaker, moving on to Part 3 of the bill, Clause 9 through 27. This section outlines the formalities for the making of an advanced healthcare directive. The provisions in Part 3 state that an adult who is mentally competent may make a directive even though that adult is not terminally ill and not undergoing any health care. In fact, Mr. Speaker, we would encourage everyone who wishes to take advantage of this opportunity to make an advance directive to do so as soon as this legislation comes into force, rather than waiting for an illness. After all, Mr. Speaker, we never know when we might end up in a situation where the advance directive may be required, whether it may be a case of a motor vehicle accident that renders you unconscious and unable to communicate with your wishes, or a sudden stroke or heart attack. It is best to have your wishes recorded in your advance directive just in case it is needed. Mr. Speaker, the directive maintains valid even if the directive maker later becomes mentally incompetent. The directive is made by completing the relevant forms in the schedule to the bill, and the directive maker is required to sign the form in the presence of 2 adult witnesses. Mr. Speaker, a witness should not be a proxy appointed under the directive or a beneficiary of the directive maker's estate, and one of the witnesses must be a doctor. If either of the witnesses knows that they are a beneficiary of the directive maker, the directive is not valid. In addition, Mr. Speaker, so as to reinforce this section, a provision similar to Section 10 of the Wills Law has been included, which speaks to voiding of a gift where a witness is a beneficiary. The witnessing doctor must take steps to ensure that they are satisfied that the directive maker is a mentally competent adult who has acted voluntarily without coercion and has been told of the nature and consequences of the directive. Any doctor who is conscientiously objects to acting on a directive shall take reasonable steps to transfer the directive maker's health care to another doctor. Mr. Speaker, a directive is considered valid even though a part of the directive is not complete if the part is optional, if it does not appoint any proxy, if it has minor spelling errors, if the directive does not contain or has deleted the checklist, or the directive is different from the form in the schedule but its effect is the same. The directive has no effect if it contains a provision wishing for euthanasia or something that would cause a registered practitioner to contravene professional standards or a code of conduct. A directive becomes operative only when the directive maker is mentally incompetent. A directive ceases to operate if the directive is revoked by the directive maker. The directive has an expiry date. On that day, or if the directive maker dies, While the directive is operative, it prevails over any right of an attorney, of the directive maker, or of the directive maker's nearest relative. Mr. Speaker, a directive maker who is mentally competent may revoke the directive in writing and sign and date the revocation. At the same time, the directive maker shall take all reasonable steps to tell any proxy appointed under the revoked directive and the witnessing doctor, if on the islands, about the revocation. Mr. Speaker, the establishment of an ethics committee is a critical component in healthcare settings. Under the legislation, the ethics committee established by a hospital may invoke a temporary order against a directive if it thinks fit until it makes a decision. This may occur in instances where a registered practitioner or any other person becomes aware that the directive maker expressed a wish to revoke the directive at any time while the directive maker was or is mentally competent. In this case, no registered practitioner may act on the directive until a decision is made by the ethics committee. If a hospital's ethics committee is notified of a revocation wish, the ethics committee may revoke the relevant directive if it's satisfied that when the revocation wish was expressed, the directive maker understood the nature and consequences of revoking the directive, and the revocation genuinely reflected the directive maker's wishes at the time. Other instances where the ethics committee may revoke a wish are instances where a person acting on behalf of the directive maker asks the ethics committee to intervene, or where acting on the directive is not the best interest of the directive maker. Mr. Speaker, a registered practitioner must comply with the provisions of a directive that is valid and operative unless there is a barred provision wishing for the denial of any health care, such as do not resuscitate, and must comply with the advanced directive healthcare principles. However, there are also circumstances where a registered practitioner can refuse to act on a directive if the practitioner reasonably believes the directive does not reflect the directive maker's current wishes and refers it to the ethics committee. If the health care specified in the directive is not consistent with the professional standards or current healthcare standards, such as in case of a new medical treatment or technology, or on a conscientious grounds, where the refusal is on a conscientious grounds, the registered practitioner must take reasonable steps to transfer the directive maker's health care to another registered practitioner. Mr. Speaker, a directive maker may withdraw consent to health care despite the directive as long as the wish was made whilst the directive maker was competent. However, if the directive expressly provides that the consent cannot be withdrawn because of a change in the directive maker's wishes, the registered practitioner shall provide the health care. Where a directive maker's nearest relative or proxy agrees with the health care provider, a second opinion may be sought and can be arranged by the medical director of the facility. And if there is still disagreement with the second opinion, a hospital's ethics committee may be asked to make a decision on the matter. Persons making false or misleading statements relating to a directive or attempts to do so will result in hefty fines of $20,000 and $10,000 respectively. Mr. Speaker, Part 4 of the bill, clauses 28 to 35, deals with the appointments, functions, and other matters in relation to a proxy. In this part, Mr. Speaker, in the making of an advanced healthcare directive, more than one person may be appointed as proxies. A person who is appointed as a proxy must be an adult, mentally competent, and not the registered practitioner who is responsible solely or with others for the directive maker's health care. The appointment of the proxy only has force while the directive is operative, and the directive is operative only when the directive maker is mentally incompetent. The proxy's role is to make decisions about the directive maker's health care as if the directive maker were mentally competent. Proxy decisions cannot be made about matters that are not about health care. They prevail only in the rights of the directive maker's attorney or nearest relative in regards to the directive maker's health care. They cannot refuse palliative care to the directive maker, and they can only instruct the refusal of artificial nutrition and hydration to the directive maker if the directive maker is terminally ill. If a proxy asks a registered practitioner to deny health care and the registered practitioner has not seen the directive, the registered practitioner must request a copy of the directive before complying with the proxy request. Until that is produced, the registered practitioner will continue to provide the directive maker with health care that the practitioner would have provided had the directive maker not made a directive. Mr. Speaker, certain criteria are required for the exercise of this proxy function. These include giving effect to the directive maker's wishes, ascertaining what the directive maker's wishes would have been, and to act expeditiously in good faith. If there are two or more proxies for the same directive maker, a single proxy can make a decision by that proxy, must inform all other proxies and the directive maker's nearest relative. All proxies have a duty to confidentiality and may renounce their appointments as proxies to the directive maker or to the doctor responsible for treating the directive maker. If the directive maker is mentally incompetent, the death of a proxy or the renouncement of a proxy appointment does not affect the directive's validity or other proxies' powers if more than one proxy has been appointed. Mr. Speaker, moving on to Part 5 of the bill, clauses 36 through 41. These provisions set out the protections that apply to a proxy and a registered practitioner operating under a directive. These clauses provide for immunity to a doctor, another registering practitioner acting on the doctor's instruction, or a proxy from being criminally or civilly liable for making a decision or acting on an operative directive, provided their decisions were made in good faith and without negligence. Registered practitioners are not compelled to provide any particular type of health care to a person unless it's a denial of health care. That is, the directive maker cannot stipulate what he or she wants, but can stipulate what he or she doesn't want. Where a registered practitioner or proxy acting in good faith communicates a revocation wish to an ethics committee, they will not be criminally or civilly liable in certifying someone as brain stem dead. Regard must be given to any codes of the practice of the United Kingdom or the Cayman Islands. Mr. Speaker, Part 6 of the bill, clauses 42 to 48, provides the establishment and operation of ethics committees. These provisions allows for the requirement in all hospitals to establish an ethics committee or to designate another hospital's ethics committee to be its ethics committee. Mr. Speaker, you'll be happy to know that our 3 hospitals already have established ethics committees under the legislation, as an ethics committee must consist of the following persons: 2 doctors, a social worker, an attorney at law or ethicist, a mental health practitioner, a registered nurse, a faith-based person, and a lay person. The Ethics Committee may regulate its own procedures but must ensure that all decisions are made expeditiously, taking into consideration the directive maker's best interests. The Ethics Committee may also allow an opportunity for an interested person to be heard on an issue before making a decision. The decision of the Ethics Committee is made by an order, orally or in writing, and may be appealed to the court by an interested person within 3 days. Mr. Speaker, Part 7 of the bill, Clause 49 to 53, outlines a number of miscellaneous matters, matters such as the Grand Court will have jurisdiction over the law in exceptional circumstances or by an appeal, provisions for the recognition of a similar directives from certain jurisdictions, namely the United Kingdom, Australia, Canada, South Africa, New Zealand, Jamaica, United States of America, and a jurisdiction that is a member state of the European Union under the Treaty on European Union. Recognized directives and recognized appointments have the same effect as if they were made under this law. However, the functions of registered practitioners and proxies under the recognized directives and appointments are those under this law and not the laws of the jurisdiction under which the directive or appointment was made. And a provision allowing for Cabinet to amend the schedule to the law by order and make regulations. Mr. Speaker, the final section of the law is the schedule which sets out the form a directive should take. The schedule has 3 parts. The first 2 parts allow the directive maker to state their wishes, indicate whether they wish to name a proxy or proxies, and specify their treatment preferences to extend their life if they have a terminal illness, are in a vegetative state, and or have an end-stage condition. The third part requires the signature of the directive maker and the 2 witnesses. Mr. Speaker, there is currently no advanced healthcare legislation, directive legislation, in the region, so we are considered trendsetters in this regard. Registered practitioners will be encouraged to have forms available in their practice, and as well as 3 hospitals will have forms for patients to access. Persons will also be able to download forms from the ministry's website. I want to re-emphasize, Mr. Speaker, that the proposed healthcare decisions bill creates the opportunity for those who wish to make an advance directive regarding their healthcare to do so. It does not compel or require people to do so. Having said that, Mr. Speaker, I do want to encourage everyone to start having those difficult conversations with their loved ones regarding end-of-life care. I recognize that it's a conversation that is not really an easy one to start. However, having those conversations now and capturing your wishes regarding your health care and an advanced health care directive may serve as a means of easing the emotional burden on family and loved ones when they become responsible for your care. The conversation is not only for when you become sick or old. We should be having them now to let others know your future health preferences in the event that you become incapable of expressing them for yourself. Mr. Speaker, the bill presents efforts of the committee chaired by the ministry. Comments received through the public consultation period, advice from the Attorney General's chambers, and the staff of the legal drafting department. I want to take this opportunity to thank them all. I look forward to receiving the support of my colleagues in this honorable House so that this important legislation can be brought into effect. Thank you, Mr. Speaker, and God bless.
I was going to call on the next any member to speak, but I think we could rise and sing the doxology. But I'd rather call on any member wishing to speak. Any other member? The member from...
No, sorry.
The member from
No,
North Side.
Mr. Speaker, I want to make it clear that I support legislation that authorizes DNR. But, Mr. Speaker, I have some reservations about the bill currently before us, particularly some of how the construct of some of the provisions in the bill. I read it several times, Mr. Speaker, and I kept wondering why it was done in this fashion. And I have come to the conclusion, and maybe I'm wrong, but it seems to be a cut and paste exercise from other jurisdictions and not necessarily bespoke legislation written for what the drafting instructions for this committee was. And Mr. Speaker, I'm going to try to be kind to the minister. But one of the first things that jumps out at me is, Mr. Speaker, is there's been some discussion here about living wills. There's nothing in this bill that says that a living will override a DNR or vice versa. And I think that needs to be specifically addressed in this bill, because you will find patients who may have a living will. And in the case, what I'm familiar with, Mr. Speaker, is in case where a patient has a living will, even if a proxy does a DNR, in most instances, the living will override the proxy's provision in a DNR. The other thing that seems to be missing is how are we going to identify people who have done a DNR? Is it by a bracelet? Is it by a necklace around their neck? Is it by a wallet card? What are healthcare professionals to look to in the case of emergencies, in the case of home visits, in the case of admitting to hospital? Do they have to rely on this thing only being placed where? In a patient's record, is mentioned briefly in the legislation, before they know that the person has a DNR, because resuscitation would most likely have taken place before the discovery of the DNR, if it is not some publicly known methodology of clearly identifying who has done a DNR. Is it going to be part of a DNR logo that is developed locally, or and Mr. Speaker, the Minister in his presentation dealt with the various sections of the bill, so I try to follow his presentation. I noticed that there is no definition of adult in Clause 2. Is that because we are simply adopting the accepted definition of an adult through the interpretation law of anybody 18 years or older? If that's the case, then why is it necessary to define doctor? That's defined in the health practitioner's law. I think that they should consider inserting the definition of an adult. The other thing that seems to be missing is how do we handle DNRs for children? I haven't seen it in the law where parents can make a DNR on a child after accident, etc., etc. And I think that, or do you have to produce some, huh? I think how it's handled now is we just accept the parent's declaration, but we're legalizing all this other stuff now. DNRs are handled now on the request of family members or patients. But if we're going to the trouble to draft this huge piece of legislation, I think we need to address all aspects of it. That's what I'm saying. Because my other concern generally about the legislation is I think it is in many ways far too prescriptive. And the risk you run with going into this kind of prescriptive detail is if you leave something out, that's what you get sued on. In other words, is this only DNR, or is it DNR/CC, or is it DNR/CC, ARR? They're all forms of DNR. One has to do with cardiac arrest, one has to do with pulmonary arrest, etc., etc. And when we're getting this prescriptive in the legislation, I think we need to be careful. My personal recommendation would be that the legislation was more general, and therefore it would encompass everything. But when you get in the kind of detail prescriptive that we had in this, and when I get to talking about the application form, I'll point out where I think the difficulties will be. And included in the clause 2 is the wide definition of nearest relative. And I'm not a lawyer, Mr. Speaker, but when it includes almost everybody in the community as your nearest relative, who has priority? Because it says spouse, children, parents, sibling, grandparents, grandchildren, uncle or aunt, nephew or niece, cousin, close friend, mental health professional, social worker, or a lawyer. When I talk about my nearest relative, if I'm married, it's usually my spouse. Next in line would be my children. And I think the risk we run here is again, it is so wide that I can imagine all of these claiming at the hospital that they are nearest relatives as defined in the law, and everybody has a different opinion as to whether DNR should take place or not. And one of the other things that concerns me in section 8, Mr. Speaker, is 8B3. Or 8B said proxy decisions are to reflect the decisions that the directive maker would have made in the circumstance. But then 3 says are in the absence of specific instructions or express views by the directive maker to be consistent with what the proxy believes the directive maker would have decided. And the decision by the directive maker should have been made on the DNR. And I'm a little curious about the 14 to professional standard or code of conduct does not include a standard or code of conduct prepared by or on behalf of a hospital, clinic, hospice, nursing home, or other place at which healthcare is provided that regulates the provision of healthcare or other services at that place. But what kind of standard is it? And I'm not sure that in 22, where it says where a directive expressly provides that it cannot be revoked because of a change in the directive maker's wishes, the Ethics Committee may only revoke the directive if the Ethics Committee is satisfied that the directive maker's state of mind at the time of revocation, the wish was made, was a conscious wish to override that provision. Again, it seems kind of convoluted of trying to say that. I assume what they're trying to say is that if I have, as a directive, asked for a DNR and I decide to stop it, that I should do that while I'm of sound mind and conscious. Because it's kind of hard for you to change a directive if you're unconscious. Or A, directive maker is mentally incompetent and receiving health care or from a hospital, and B, a person acting on the directive maker's behalf asks the Ethics Committee to revoke the directive. Two, again, is curious. The Ethics Committee may only revoke the directive if the Ethics Committee is satisfied that A, acting on the directive would not be in the directive maker's best interest, and assuming the following medical advances since the making of the directive are likely to cause the directive maker's health care wishes to be significant or different from those under the directive. What are we trying to say? That if I ask for a DNR and there's some medical invention in some other country, the DNR can be revoked by the Ethics Committee. Section 23, notwithstanding Section 22, a registered practitioner may refuse to act on a directive the practitioner, A, reasonably believes the directive maker did not intend the directive to apply in a particular circumstance. How is that going to be determined? If I've done a DNR directive, it's a DNR directive. What particular circumstances should a doctor be able to second guess my request to have a DNR? Reasonable believes the directive does not reflect the directive maker's current wishes and the registered practitioner complies with Section 18. 2, a registered practitioner may refuse to comply with a provision of a directive that specifies the type of healthcare the directive maker wishes to receive if the provision is not consistent with any relevant professional standards, or B, does not reflect the island's current healthcare standards. How are we going to measure the island's current healthcare standards? Because we're making a decision here that a physician can refuse to comply with a DNR directive because he believes that it does not reflect the current healthcare standards. Where are the measurement devices to determine what the healthcare standards are? 4, a registered practitioner may refuse to comply with a provision of a directive on conscientious grounds. Where a registered medical director refuses to comply pursuant to Section 4, the registered practitioner shall take reasonable steps to transfer the directive's maker's health care to another registered practitioner. What is reasonable steps? If a physician is attending to a patient and the patient has a DNR and the doctor for conscientious reason does not want to carry out the wishes of the patient and the DNR, the transfer of the patient to another doctor for care should not have this reasonable steps. What's reasonable steps? Make a phone call and the other doctor didn't answer the call. So he continues to resuscitate the person against the person's wishes and create medical bills that the family can't afford. Because, Mr. Speaker, one of the things that we need to understand here, is that we all would like to pretend that DNRs are based on ethics and comfort for the patient and all that. But in this day and age, DNRs has a very serious economic value and consequence to both parties. To the healthcare facility rendering the care, because in many instances, regardless of how futile it is, as they continue to render, they can continue to bill. And vice versa. So we have to be, I think we need to be more definitive. I think that the law needs to say that if a physician is refusing to carry out a DNR, which is properly authorized according to the law, on a patient, it should not be no reasonable steps. It should be transferred immediately to another doctor. And if he doesn't transfer it, then he should be guilty of, under the law, of refusing to comply with the DNR. And, Mr. Speaker, I can understand the need to insist that a doctor must be a signature, particularly if patients are intellectually incompetent or medically incompetent or not in a position and may not have understood the ramifications of the DNR. But insisting that for people like in my constituency, it's not easy to get a doctor come out there to your house these days, They don't like to do house calls anymore to sign DNRs. And our doctors going to be allowed to charge for a house visit for a simple signature on a DNR? Mr. Speaker, the provision in Section 42, I really would encourage the government to rethink. Section 3 says, requirement for hospitals to have an ethics committee. And the law says each hospital shall have an ethics committee to perform functions under this law for its patients. So it's not intended that it can be, but it's not limited to existing ethical committees in hospitals. It says a hospital may establish. One, we say they shall have. Section 2 says they may establish its own ethics committee. Then we throw the government in, and the government accepts all liability. If no ethics committee has been designated, ethics committee of the Cayman Islands Hospital shall be taken to have been designated as the ethics committee. The law should stop, in my view, at 42(1), or at least the may in 2 should be shall, and we remove 3. because that can carry quite a bit of liability if DNR is not enforced and you run up a $500,000 bill. And $500,000 bill is not difficult to do in the healthcare business, you know. Especially when people are in intensive care or in trauma centers, where they usually have 3 or 4 or 5 doctors and various specialists work out at the same time. So I think that certainly in the local market, the law should say, as it says in 1, shall have an ethics committee, and a hospital shall establish its own ethics committee that deals with this. Because the other question that I would ask is, if the HSA is going to be the ethics committee, is that only the ethics committee for the purposes of this law? That's not what it says. Is that ethics committee going to have jurisdiction over other healthcare facilities for other ethical decisions within the organization? And we keep putting this thing in here about these committees that we set up having the ability to enforce one subject to Section 45, which is procedural for fairness requirements. An ethics committee may regulate its own procedures for deciding issues that come before it. Under Part 2, the ethics committee shall ensure that all decisions are made as expeditious as possible, having regard to the relevant directive maker's best interest and the duty of public officials under Section 19 of the Constitution. If you don't put it here, you might want to put it in regulations. You have some kind of procedures as to how these decisions are documented and how they're arrived at. Because I can trust you, they can be subject to legal scrutiny. And this one is really curious. In the same section, Mr. Speaker, 45.4 says an ethics committee may, but need not, conduct inquiries and act on any information or opinion it has, forms, or obtains about an issue. Are we suggesting that ethics committee can arbitrarily decide without conducting any kind of inquiry? Again, I think that needs to be more definitive, and it should require the ethics committee to conduct an inquiry and to document that inquiry properly and legally. In my view, again, not being a lawyer, but you know, they spit on the thing and put it up, see where the wind blows. And say, we're not doing it. We're revoking it. Because, Mr. Speaker, these are not minor decisions. This is not about using a gauge 18 needle or a gauge 25 needle to give an injection. These are important and serious medical decisions, and expensive ones. And we need to make sure that they are being done properly. And Mr. Speaker, again, getting back to the prescriptive nature of the bill, why are we specifying only 8 jurisdictions that we accept this from, and we're not including some of the other neighbor countries around here, or some place like, excuse me, the other countries that we have thousands of nationalities here? Yeah, but still, at least, so we're going to go back and change the law after if somebody else does one? Well, it might be simpler to say include all those who have than it is to leave out some that go. Anyway. Okay. Now, Mr. Speaker, this application form is uh, 10 pages long. 10 pages. I have seen non-hospital orders for resuscitation that are less than half a page. This is going to intimidate most Caymanians. You put this kind of form before them, they're not going to be bothered with it. And one of the things that we really don't need to do in this form is to say that a doctor must provide care. If I say no, if I don't say no, because that's governed by his licensures and morals and his ethics and everything else in his procedure. Let me give you a quick example, Mr. Speaker. Cases of terminal condition. If my doctor certified that my death from a terminal condition is imminent, even if life-saving measures are, one, keep me comfortable. This is what you are declaring you want done now. Keep me comfortable, which includes medication to relieve pain and distress and allow natural death to occur. I do not want any medical interventions used to try to extend my life. I do not want to receive nutrition and fluids by tube or other medical means. Or, keep me comfortable, which includes medication to relieve pain and distress and allow natural death to occur. I do not want medical interventions used to try to extend my life if I am able to take enough nourishment by mouth. However, I want to receive nutrition and fluids by tube or other medical means. 3, try to extend my life as long as possible using all available interventions that is reasonable medical judgment would prevent or delay my death. If I am able to take enough nourishment by mouth, I want to receive nourishment and fluids by tube or other medical means. That's the doctor's normal obligation in healthcare. You don't need to put it in the application form. A doctor's job is to extend my life unless I have ordered a DNR using all possible means. And if we're doing DNRs, it only needs to be in the negative. I do not want. You don't need to have 2 negatives and 1 positive on the same form. And Mr. Speaker, terminal condition is one category. Preference in case of persistent vegetative state is another category. Preference in case of end-stage condition. Not sure what the difference is between terminal and end-stage condition, because end-stage condition is not defined in the clause 2. In case of pregnancy, effect of stated preferences, and then we put all that in the form, Mr. Speaker, and then we go on to say that if some section of the form is left blank, it's still a good form. We should only put in the form the information that we require, and if all of the information is not there, the form should be good. But we're putting all these alternatives that are not necessary, and giving the caveat that if you don't complete the unnecessary part, the form is okay. And this one, one of the options we're giving people under powers and rights of proxy is that we're allowing people to prescribe that their proxy must ride with them in the ambulance. Are we going to modify the ambulances and allow cousins, aunts, uncles to ride in the ambulance with a patient from the north side? The last time I looked in the ambulance, they were kind of crowded up, and then once they put that stretcher in. And again, why are we making what I believe, Mr. Speaker, are unnecessary allowances in this? Because if you pick up the patient, you ought to be able to tell the proxy where you're going. And it says here under powers and rights of proxy, these powers and rights will only apply while you are not mentally competent. I thought you had to be mentally competent to appoint the proxy. So you might want to look at that wording as well. I want my proxy to have full power to make healthcare decisions for me, including the power to consent or not consent to medical procedures and treatments which my doctors offer, including things that are intended to keep me alive, for example, CPR, cardiopulmonary resuscitation, ventilators, and feeding tubes. And you have a DNR? So, what are you giving this to the proxy for? The proxy, do you have gotten a DNR and you're saying no resuscitation, but you're giving the proxy the authority and the power to override the DNR that you created? Or that you asked the proxy to create for you? And this one is really, really serious. Decide who my doctor and a healthcare provider should be. And 3, decide where I should be treated, including whether I should be in a hospital, nursing home, or other medical care facility or hospice program. Remember the discussion the Premier raised here the other day about health insurance and where people go? This doesn't say on island, you know. So this is where I have my concern, Mr. Speaker, about what appears to me to be cut and paste legislation, and I think that it needs to be more localized and so, Mr. Speaker, I think that there is some changes need to be made to this legislation. While I support the ability for people to have a DNR, I'm not sure that I can support this legislation in its present form because of those concerns. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? If not, then I'll call on the minister to reply. Before the minister starts, I would ask for a suspension, 15 minutes.